Hello, my name is Tim Wilson. I'm a patent attorney at Dehns, specializing in patenting software and electronics related inventions. And today it's my pleasure to talk about AI inventions. As you'll no doubt be aware, AI is everywhere in the media these days, from exciting predictions about how it's going to transform technology and innovation to more concerning headlines about machines taking over the world. But my hope today is to spend a few minutes demystifying something of the topic of AI in relation to intellectual property in particular. What can be patented and what may not be able to be patented in the field of AI. So where does potentially patentable artificial intelligence exist? Well, it's been a pleasure over the last few years to be working in software and particularly in AI, not least because it's cutting across a whole range of traditional sectors in engineering and chemistry and biochemistry, where there's transformative work going on due to AI. So we've seen it cropping up in fields as diverse as autonomous driving, robotics, voice recognition, molecular drug discovery, translation software, all sorts of different areas. And so including where some of our clients may not traditionally have been involved in patenting software, now that AI is opening so many new doors, the potential for protecting valuable intellectual property is cutting across a lot of traditional sector boundaries. So what might be potentially patentable in terms of the use of AI? Well, at a broad level, artificial intelligence can be used to classify data. The classic example being pictures of dogs or cats as shown here, but obviously far more practical uses in many real world situations, as well as decision making. And then also discovering patterns in data, in statistical data or other signal processing. And then in the generative AI, which is the one that's hit a lot of the headlines recently with ChatGPT and the like, creating very realistic works of literature or artwork or music. Thinking just briefly about intellectual property in general, what do we mean by intellectual property? It's the legal system that governments have created to help incentivize and stimulate creativity through innovation and business. And there are a number of different intellectual property rights that you may be familiar with, including copyright, designs, trademarks, patents, confidential information and trade secrets, and there are some others, but particularly for AI, the ones that are most relevant, along with copyright, that may be helpful for software generally. But what I'm going to focus on today is patents and a little bit about confidentiality and trade secrets. So patents have a long history dating back hundreds of years to incentivize innovation by protecting new solutions to technical problems. And they traditionally may have applied in chemistry or engineering, but more recently, software has also been seen as patentable in some cases, which I'll discuss in more detail. To get a patent, you have to apply and pay some fees for a substantive examination to take place. And the patent offices will check that an invention has the requisite degree of novelty and inventive step compared with anything that's been done in the world before that's in the public domain. But as I have hinted at, there are some exclusions, particularly in the field of software, as to what can and can't be patented. And so I will talk a little bit more about those now to help give you some feel for what it may or may not be worth trying to protect in this area of artificial intelligence. So to think about some of the opportunities for patenting and protecting value in AI, there's a long history of patenting machine learning related inventions. This patent I found, for example, dates back to 1966 and relates to a learning machine, not entirely similar to the modern neural networks, but it has some of the some very interesting features there. Why might you want to patent artificial intelligence? Well, not only obviously is AI expanding rapidly, providing lots of opportunities across a whole range of business sectors, but by protecting that innovation, patents can add value to a company and attract investment. They also provide some marketing opportunities to have IP protected or patent pending status, as well as being useful for underpinning licensing and investment deals, having some legal protection for ideas, particularly can be valuable for early stage or university related innovation. And patents, of course, ultimately they're a negative right. They give exclusivity to an invention, and so they can deter competitors from copying your hard work for developments. And they can also be used as a defensive strategy in case anyone asserts intellectual property against you. Having some of your own rights there can be useful as a deterrent or a defense. So what might you want to patent in this field? Well, there are a number of different areas. There could be some fundamental new AI mathematics, algorithms and models at a very general level. But more what we're seeing from our clients is the idea of applying artificial intelligence to a particular problem that people are facing. And then there's also the practical application of that. How do you train the model? How do you get the data ready to do that, as well as the use of the trained model? So what can be patented? Well, in general, across most countries, the approaches can differ a little bit, but broadly speaking, if there's a technical solution or development as in a sort of software engineering innovation, that is likely to be patentable. If the innovation lies more in the commercial or business idea, that might be more challenging. How that's expressed differs a little bit between different countries and regions, but at the European Patent Office, they're particularly looking for a technical application or technical solution to a technical problem. Whereas the United States phrases it a bit differently in terms of what is non-abstract, and purely mathematical ideas would be seen as an abstract, but something that's applied to a particular problem may then take it outside the realm of being purely abstract, but be something more. China, Japan, and many other countries apply similar sorts of criteria. So thinking just briefly about the European Patent Office in a little bit more detail, formerly artificial intelligence and machine learning inventions are treated the same way that the European Patent Office has historically treated any software-related invention, that it must claim a technical solution to a technical problem. And so in practice for artificial intelligence, that means that very general ideas of a new type of artificial intelligence approach can be excluded from patentability as being mathematical methods as such. However, if they're applied to a particular technical problem or purpose, or to particular hardware, then that can bring them back into the realm of patentability at the European Patent Office. Similarly, data sets are excluded from patentability in and of themselves, but methods of generating or pre-processing data for training a model, for instance, may be okay and patentable if those methods are technical. The United States has no legal exclusions to software and mathematics, but as I mentioned, you can't patent an abstract idea. Exactly what will be considered abstract or not abstract is not entirely settled, and in practice can vary between examiner and to examiner. But in general, a novel algorithm that's implemented on otherwise conventional hardware and for a general purpose may be refused as abstract. But if you have the conditions that I mentioned for the European Patent Office present of applying them to a specific technical problem, then you could well be hopeful of getting it through in the United States Patent Office as well. So to think about a few practical examples of what may be patentable, adapting a particular machine learning technique to a specific technical problem. What do we mean in practice by that? Here, for example, is an example of processing on a digital camera images to determine whether differences are due to motion artifacts as the camera moves, or simply lighting differences between different frames in a video or different photographs, and then allowing the video camera to act appropriately on that. So here, machine learning was used to train on data sets of images that just had motion artifacts and others that had exposure differences, so that the software could discriminate. And so that is doing something very practical and useful, processing digital images. So that would be potentially patentable. Another example of something that could be patentable in the realm of autonomous vehicles is taking a camera feed from a car and working out where different road features are, lane markings, the edge of the road, other vehicles, and so forth, and adapting machine learning techniques to solve that particular problem. It could well be potentially patentable inventions there, so long as they meet the criteria of any patentable invention of being something new and having an inventive step. Another example in the field of medical imaging, here, if you were cleaning or pre-processing data in order to help improve a machine learning process, for example, to allow a model to converge more quickly during training, then some of those pre-processing steps that you might apply to the scan data that's obtained could potentially be patentable, even if the actual machine learning technique that's then used is more conventional. Then if you have an invention that's tied to specific hardware, for example, a new type of chip or hardware architecture for implementing neural networks, then that could also be another area of patentability. So, for example, if you have a memory manager for processing large data sets efficiently on a resource-constrained platform, then the hardware and potentially some of the algorithms for managing the data might be patentable. So that's some of the areas where there may be patentable subject matter to be found. What are some of the challenges? So I mentioned across a number of jurisdictions, the mere idea of applying machine learning to a particular problem is unlikely to be patentable unless there's some new technical innovation. So simply recognizing that a process has been done manually in the past and that it can be sped up by training a computer to do the same process, but in an automated way, isn't going to be patentable if the techniques that are used are conventional ones. Similarly, well, also, if you have new fundamental mathematical ideas at a sort of a fairly low level, but not applied to any particular problem, there may be challenges there with those being seen as unpatentable as mathematical methods as such, or being abstract. However, applying them to specific problems can then help to improve that situation. So what are the practical challenges when preparing a patent application? There's the challenge of identifying where the actual inventive contribution lies. A lot of machine learning systems are quite complex, and the whole number of different innovations have gone into developing them and optimizing them. Working out where the best target is for applying the patent application and what to claim isn't always straightforward, but by working with a patent attorney to look at all the different aspects and the tuning of parameters and so forth, that can help to identify where the key differences are that have helped to unlock a new valuable innovation, and then targeting the patent there can help. And the patent application needs to demonstrate that it's solving a technical problem, and to try and head off any objections of it being abstract. And then defining with sufficient clarity. Sometimes some of the terms that are used, like big data or agent architecture, might be objected to by patent examiners for not having a precise or clear enough meaning. So again, the inventors and patent attorney will need to work together to make sure that sufficiently precise claims are drawn. And then there's a challenge which is sometimes may not always come up during the examination process, but could certainly be raised in any post-patent grant situation in a court setting if a patent's ever asserted, which could be whether the invention actually works and whether sufficient detail is included in the patent to enable somebody to actually implement and build the invention. And so that might be challenging, particularly if the data sets that are used in practice to implement the invention aren't in the public domain. Then there can be challenges with showing that actually it is possible to build and implement the system. But again, these things can be worked through with your patent attorney to try to do the best, present the best case that is possible. In terms of commercial considerations of how to protect artificial intelligence related inventions, there can be an issue as whether detection of infringement is straightforward. So for example, if the artificial intelligence algorithms run on a server that is never accessible to the end user to examine, then it may be hard to know whether a competitor's system that's also on a server actually implements the same method or not. And so in particular in AI, it could be hard to prove how a network was trained, even if it is possible to examine the software that a competitor is issued, how they trained it. If the training was done as a sort of pre-production step, might be hard to demonstrate. And there could also be some jurisdictional territorial issues because patents are national rights. And yet computer-related inventions can often be spread across multiple countries, with a server partly hosted in one country and partly in another, and end users in a third country as well. And so those considerations need to be taken into account when preparing a patent application. So these can be mitigated, as I mentioned, by careful thinking through when drafting a patent, but also by considering where it is appropriate to protect an innovation through the patent system, and when it may be better to keep something as a trade secret or confidential information, and particularly if an invention is being hosted in a way that can protect privacy, it may be that sometimes trade secrets are more appropriate. Finally, any presentation on artificial intelligence and patents wouldn't be complete without giving a brief nod to the idea of whether ultimately one day systems themselves, AI systems, might be producing inventions that can be patented, for example, in the field of drug discovery. This is something that has already been tested to a degree with the patent offices, with people presenting some example patents where they've claimed the inventors to be computer programs. For now, the patent offices have come back quite clearly saying, no, you still need a human inventor, and the person who invented the software that comes up with the drug discovery would at present be the inventor and the owner of the invention. But interesting to watch this space, because that may or may not change in future. So in summary, artificial intelligence is an exciting field. There's lots of innovation going on across a whole range of industries. Patents can play a part in helping to encourage investment and licensing and technology development and dissemination in that area. But there are some challenges when looking to patent artificial intelligence. So patents need to be used carefully and appropriately, with good strategic decision-making in order to maximize their benefits and avoid some of the pitfalls that I've touched upon. So Dehns has a number of attorneys alongside myself working in the area of artificial intelligence, and across the many other areas of engineering and chemistry and biochemistry and trademarks. Some of the stats are here for your interest. But if you do have any questions or would like any advice on how you might be able to better protect any innovations in artificial intelligence, please don't hesitate to send me an email, and I'll be very happy to speak with you about that. Thank you. I look forward to hearing from you.